Members Craig Eiland here on behalf of TTLA, but also specifically for myself because I have utilized this, and I want to tell you how and why. I also want to thank Mr. Krause for his open door policy and for discussing this with us, and you as well. And I've got to be careful of how much I say because I don't want to disclose too much. But I was an investor.
First, disclose your position on the bill.
I'm opposed to the bill,
Thanks.
individually and for behalf of TTLA. So in my situation, I'm an investor in a business, and after a couple of years, there was a tortious interference by somebody else in that business. They took it over and took it away from us, involving millions and millions of dollars. But us investors, I mean, we just lost our money. We know that we got to have a lawsuit to try to get the business back and or for the tortious interference. And to do that, we need to get big-time lawyers that can go do it. I mean, it's a big deal. But we just lost our investment. We don't have any more money to chase after. It's a good case, but we don't have any more money to chase after that hole. And so we went out and borrowed and got third-party financing so that we could go hire a really good lawyer to take us to the winning line. And we're almost there. But if the defendant knew what our arrangement was, if the defendant knew how much we had, they could wear us down or wear us out or settle. If they knew what the arrangements were, they could figure out how to settle the case one way or another because we were going to run out of money or wear us out. So that's my own personal concern about this bill, is I don't want the defendant to know, number one, that we use third-party financing. And this bill, when I'm a young lawyer starting out, it would require me to disclose to you that my parents loaned me money to start my law practice to fund the case. Now, what business is it of yours that my mom and dad loaned me money? They are third-party financiers under this bill, and I'd have to disclose that my mom and dad loaned me money. For what purpose? For what purpose, except your own curiosity?
Mr. Chair.
Yes,
I think
Chairman Meyer.
the purpose is just like a certificate of interested parties, right? Like maybe if it's not the amount, but maybe, and I'm not saying this would happen in every instance, but I could certainly see an instance where a third-party backer might have an interest in the outcome of the litigation. Maybe I'm a competitor against the defendant, and I really want to fund this plaintiff because I want to run my competitor into the ground. Shouldn't that be something that folks should know about? And I get maybe the amount because I see what you're saying. If they know you have $100,000 and that's all you got, and that's where you had to go, they'll draw out discovery. They'll have notice depositions wherever they can, and I'm with you on that. But explain to me your point as it relates to, and I just pulled that out, the competitor versus a competitor. Don't you want to know? Wouldn't you want to know there might be an ulterior motive there, and it's just not the altruistic thing of let's let this plaintiff get across the finish line. It's I've got something that maybe I shouldn't be involved in that I am, and if I have to disclose that, maybe the competitor doesn't get involved in litigation.
Okay, so let's make sure that we apply that to everybody, because if it's going to be disclosed, because right now we have the collateral source rule that the jury doesn't get to know if you have health insurance or car insurance and how the issue is going to be paid. But if I need to disclose that as an interested person, like you say, then I know Mr. Krause used to work for Liberty, right, and take donations, right? I don't know who those donors are. They may be competitors on some case they're in. And so they may want to fund something. So if I've got to disclose that my mom and dad are giving me money to finance the case, why wouldn't we make donors often in public, I don't know what you call it, public policy litigation, public interest litigation. So if we're going to disclose, let's all disclose everything, which I don't think we should. But if I've got to disclose, then we ought to disclose to the jury who's going to be paying the verdict with insurance, or who is funding the public policy litigation. I mean, where do we stop if we start this?
Chairman Meyer, do you have other questions? Okay, Representative Krause.
Well, thank you, Chairman. I was going to say I do think it's good to be remembered that the Supreme Court's going to be the one promulgating these rules as well, and I think they're going to go through the the routine of deciding what information needs to be shared, when it needs to be shared. I mean, they could say if you're within the second or third degree of consanguinity, then you don't have to disclose that, like we do in a lot of other legal places. I could see an exception for 501c3s or nonprofits. I think that's much different because when you're on the other side, it's just a lot different than you're with for-profit. So I think we need to remember that, and that could help maybe alleviate some of these concerns, but maybe not too. And I did appreciate you coming, and I enjoyed talking with both of you about this, and we'll continue to talk to you about this as we work on this.
And
Representative Davis.
I just wanted to ask Representative Krause, and I guess while we have Mr. Eiland testifying also, what happens to poor people and their right to be able to get in a courtroom and have legal representation? We won't know the big investors. We won't know the competitors. We will have just gotten hit by a big truck. We can't take care of our families. I think we cannot ignore that those are real issues in everyday life. So what happens to their ability to get legal representation? Because if somebody's got to disclose that I paid someone's rent, or if someone's got to ask for support to pay their rent, you're not going to get that kind of support and or willingness to say, I can't take care of my family. I can't meet my family's needs. And basically you're creating another barrier to get barrier from poor people being able to get in the courtroom to have their day in court and be protected under the law. So I mean, is that where we're trying to get to, that point?
Representative Krause.
Certainly, that's the last thing that I want to do with House Bill 2086. And we've already looked at some other people have brought us those concerns. We're looking at a language that could be added as a committee substitute that would ensure that didn't happen. Because that's not the point of it. It's just a transparency measure to make sure, as Chairman Meyer, I think, pointed out, sometimes it's helpful to know, it's beneficial to know, maybe not the dollar amount, but at least if a third party's in it, and, that may give you some clue. But your point is very well taken, and that's certainly language that I'm open to working on.
Thank you, Representative Krause.
To close,
Yeah, Mr.
Chairman,
Thank you.
two closing thoughts, especially Chairman Morgan. One, I don't have to disclose my line of credit. The one that I have a line of credit, that how much my line of credit is, where I am on the line of credit. And so why do we need to disclose anything that's not a bank line of credit? One.
Chairman Meyer.
Because banks do that line of credit, whether it's litigation or your house or a car, or that there's a myriad of different reasons, and banks are in that space because they do it on myriad of different. And I'm just giving you a counterpoint. I'm just saying I can see why banks would be different than maybe the investors investing in litigation. Sorry to interrupt. Please go ahead.
I think you're here from, and the last point is, there's times when a lawyer like me could have a chance to go get into a big case if I can go get third-party financing and not have to put up all of my risk, everything that I have, because I may not have enough. The other big firms like Mr. Gallagher or these other big firms, they don't need third-party financing. They got plenty of capital. They got cash. They got big lines of credit. They don't need it. And so you're going to be pulling up the ladder for some law firms that they can't participate and can't help their clients. So they got to refer it to one of those whales, that does have the line of credit and does have the capital, doesn't need third-party financing. So you're eliminating some options for mid-sized firms or mid-sized lawyers to help their clients, and not, like we talked about earlier, not referring them on to people they don't know.
But it's not saying you can't go get third-party financing. It's just requiring you to disclose it.
Right, and then we don't know where it goes from there because we give the Supreme Court no guidance. And my point is that I've got to disclose it. What are they going to use it for? It can't be to my advantage, or they wouldn't want to know it.
Representative Krause, you have a... Okay.
Always appreciate it.
Yeah. Thank you. Members, any other questions? Okay. Correct, thank you. Thank you.